Hello students, welcome back to Mendes. This is your law of contract third session and probably we will be winding up contract in this session. In our previous sessions, we have discussed about what is a contract, what is an agreement, what are the different kinds of offers and what your consideration actually is, how a contract will become void and what are voidable contracts. We have discussed every important points in our previous two sessions. So if you haven't watched our previous classes, please click on the I button and go back and watch those classes. That will be super useful to you. And now in today's session, we will be dealing with some important concepts and important types of agreements. Like we'll be dealing with wagering agreements, we'll be dealing with contingent agreements, we'll deal with quasi contracts and how a contract is breached, like a breach of contract, and then we will deal with what are the remedies on breach of contract. That will be all that we'll be dealing with contract in this series. So probably we will end our session on that. So let's move on to our wagering agreements and contingent contracts. So you need to understand what a wagering agreement actually is. Okay, before reading that, I'll simply help you understand what a wagering agreement is. Wagering agreement simply means betting upon a thing. Okay, sometimes you will be betting with your friend that today it will rain. You're telling your friend that if it rains, I will give you 500 rupees. Okay, if it does not rain, you will have to give me 500 rupees. So we are making a bet. We are not performing anything. We are not a part of anything. We are not doing anything. We are simply making a bet upon a future uncertain event. Okay, betting. Wagering agreement basically means betting. Okay, so let's read what a wagering agreement is. A wagering agreement means a bet. Wagering agreement is one in which reciprocal promises are made to give money or something of value upon the result of a future uncertain event with regard to which parties hold opposite views. So if you try to read it yourself, you might become confused. You can read it yourself. So you will become confused on what a wagering agreement actually is. It's very simple. Okay, it's very simple. It just means you're betting. You're betting on a future uncertain event. A future uncertain event. You don't know whether it will happen or you believe it will be going like that. The other person believes it will be going the other way. So you have an opposite view on a future uncertain event. You have opposite views on a future uncertain event. So that's basically what a wagering agreement. You are making reciprocal promises. You are making promises which with each other. Okay, that's a basic thing in opposite way. You are making promises with each other in opposite way on a future result of a future uncertain event. So this will, if you understand this concept as betting as itself, it's easy for you. So what happens with the wagering agreement? You must understand that also. What happens with the wagering agreement is wagering agreements are void. So this is the most important point. In previous classes, we discussed about different kinds of void agreements. So wagering agreements comes under that, and wagering agreement means void agreement. So keep that in mind. Okay, a wagering agreement is a void agreement. So keep that in mind. Wagering agreement is a void agreement. Wagering means basically betting. Okay, keep that in mind. So bettings are void. It will not be enforced in a court. That's what they mean by it. Then you might think, so what's with lottery? Lottery and all in different states there are different rules relating to lottery, different rules relating to casinos. See, understand the Indian Contract Act considers it as void, but there are other laws relating to it. Okay, in Kerala, you can the Kerala Lotteries Act. So every state has their own law regarding it that governs such kind of wagering agreement. So under Indian Contract Act, remember Indian Contract Act considers wagering as void. Now contingent contracts. What next comes is contingent contract. Some people confuses if you do not understand the core concept, you will be always confused between a contingent and a wagering agreement. Even if you read it yourself, you still would be confused with both. Let's try to read it. A contingent contract. A contingent contract is a conditional contract. In case of a contingent contract, the performance of the promise depends upon the happening or non-happening of some future uncertain event. Okay, the performance of promise, you read it, the performance of promise depends upon the happening or non-happening of some future uncertain event. So what is common here? The common element here is the happening or non-happening of a future uncertain event. Future uncertain event. So people think, so here they are also making a contract based upon future uncertain event. Here is also a contract based on a future uncertain event. So you might simply guess that contingent contracts are void contracts. Your answer is wrong. Contingent contracts are valid contracts. Contingent contracts are valid contracts. Okay, you have to understand that. So what makes a contingent contract valid? Now you have to understand. So there is a big difference between both of them and you couldn't get it. Okay? You couldn't get it from the statement. So this is a valid. This is a valid. Okay, my handwriting is very bad there. It means valid. Okay, it's a contingent contracts are valid contracts. It will exist. It's not void. It's not voidable. It will exist. So now look at it. Compare it. What is that difference between these? Wagering and contingent. What is that big difference here? If you read it properly, you will understand. Here, future uncertain event is just a condition. Okay, it is a prerequisite. Okay, and in wagering agreement, what you are making a contract upon itself is the event. Everything is about that future uncertain event. That is the key difference between wagering and contingent contract. In wagering contract, you are saying that it will rain. I am saying it will rain. The other guy says it will not rain. So here you are betting, you are making your whole contract about a future uncertain event. So in contingent contract, I will tell you an example. In contingent contract, I am telling my friend, okay, no, I will give 2 examples. One example, I am telling a farmer, I am a big businessman, I am a big exporter. So I am telling a farmer, okay, if you produce A class, A grade quality potatoes, I will buy 100 kgs from you and I will export it for a particular price. And I am specifically mentioning that if you are producing a grade potatoes, A grade export quality potatoes. So the prerequisite here is he has to produce such a quality potato. If he is producing potatoes that are of not that quality, I will not buy from you. So that is the future condition. The crop may be of good quality, may be of a bad quality. Sometimes he might not even produce this potato. There will be some flooding or other issues, and sometimes the crop may not even grow. So I am making a condition. Or else, another example is I am telling my friend that I will buy your house from you. Otherwise I will buy your property from you for some price if you succeed after your father. Okay, if your father dies and if you get the property, I'll buy that from you. Okay, or if you are getting this company, if you are succeeding your father as the company proprietor, I will buy these shares and I will give you these projects or something like that. So that contract will become binding. Or if I have signed such a contract, it means what? He have to succeed. Okay, his father will have to die or he have to make him his successor. That is a future uncertain event. If your father dies, I will buy your property. So first his father has to die anytime, sometime soon. Because we don't know when that is going to happen. So here the future uncertain event is a condition. That is what you have to understand. In contingent contract, this future uncertain event is only a condition, okay, for performing the promise. My promise is I will buy your share, I will buy your potato. Okay, I will buy your potato. So that is my promise. I will complete my promise. I will perform my promise only when you have completed the condition. What is that condition? It has to be of such quality that I have mentioned, of that I have made a condition upon. So that's what it is here. The future event, future uncertain event will be a precondition or become as a condition for performing your promise. On the other hand, in wagering agreement, the future uncertain event itself is upon which you are making a contract. You are not making, you are not doing anything. You're not doing. He's cultivating a crop. He's doing something, and I am doing my promise. Here, no one is doing anything. We are just watching whether it will rain or not. We are just watchers. We have no role to play. We have no performance there. So that's the thing that is there. So wagering agreements are void. Okay, under Contract Act, wagering agreements are void. What you have to understand for your exam is, when a passage is there about wagering agreements, you will be saying wagering agreement. There will be words like wagering, wagering, wagering. You will not understand what wagering is basically. So you have to understand that concept. When a passage mentions about a wagering agreement, you have to understand. So this is a contract based upon a betting. Wagering agreements are void under law. And if you say heading with a contingent contract, you have to understand these concepts. Contingent contracts are also contract that is depending upon a future uncertain event, but these are valid contract, because here it is a the contract depends upon the future uncertain event only to the extent that it has to be done. So it has to happen, or it has to be done so that I can complete my promise. So here it becomes a part of a contract, but in wagering agreement, the future uncertain event is what upon which the contract is made. So these are the key concepts that you have to keep in your mind. That's enough. You have to keep these things in your mind so that you can read those passages easily. Okay, you can understand those things very easily. You have to keep these key things about these two contracts in mind. You don't have to by heart anything. Just have to understand these two things. The difference between a wagering and a contingent contract might seem like same, but they are not the same. One is void, the other one is a very valid agreement. So if you confuse with these two, your answer would become very, very wrong, because these two things stand at two extreme points. One is valid, one is void. So let's try a few questions which are very, very easy questions. Which one of the following best defines the wagering agreement? Okay, you can only choose one of them. You can only choose one of these options. So I'll move away from the screen and you can read it. A contract based on mutual trust. Both people are trusting on each other. A contract depending on occurrence of a future event with insurable interest. Okay, think about that. Occurrence of a future event with the insurable interest. Then a promise made based on a chance where one party gains, the other loses. An agreement where both parties benefit regardless of the outcome. Which one best defines? You have to find a best definition. Okay, you don't have to find which one. Not everything which is close to that definition is not what you have to find here. What you have to find here is the best one of these. So it's very simple. Sometimes there will be a confusion between B and C. Okay, the answer is C. I will discuss what B is later on. So C, a promise based on a chance. A promise based on a chance where one party gains and the other loses. When there is a reciprocal promise holding opposite views and one person will win. That is basically what is betting is called. So C is the right answer. Then let's look into what is B. A contract depending upon occurrence of future event. Okay, first of all, even if you don't understand the depth concept here. Here, future event, it is not, it in itself is not talking about future uncertain event, but let it be there. Occurrence of future event with insurable interest. So, the insurance, you might think, so insurance, is insurance a wagering agreement? Is insurance betting? Then it would be void, right? Yes, think about it. Is insurance wagering? Is it a wagering? I will pay, you have a car insurance, and you are like, if I'm telling you that if you hit your car on your wall or if you met with an accident, I will compensate for your losses. That is basically what insurance means. So if you think about it, you'll be like, okay, I'm doing something. My vehicle may met with an accident, or my shop will get into fire, or these are future uncertain events, right? These are future uncertain events, and insurance is basically a contract upon that. So you might feel like these are wagering contract, but is that so? Actually, insurances are indemnity. Okay, that is a different kind of contract. Okay, insurance is a indemnity. We call that as indemnity. In India, in England and other countries, there is only one law, that is indemnity law, that deals with insurance. But in India, we have the concept of indemnity there, and also a separate insurance law. Okay, so we have separate insurance related laws are there, and there is also indemnity, which is criticized by many European nations because they have the indemnity rule there. So we have both those laws. We have a very specific sets of rules for insurance, but basically the concept is it is indemnity. So they are not betting on. We are not making a bet on if your car meets with an accident, I will pay you money. If your car does not meets with money, you have to pay me money. We are not making a target day, or we are not going to pay the money if we are not meeting with an accident. We have to pay the insurance amount. We have our premium every year. Okay, even if it hits, or even if it does not hits, even if it's meet with accident, or if it doesn't meets with accident, we have to pay the premium. So it is not a betting. So it is a indemnity. Okay, we will deal with indemnity later on. So insurance, here we are talking about insured interest. Okay, insurable interest, our protected interest. We are talking about our protected interest. So these are not what a wagering agreement. Okay, so what best define is C. So keep this in mind for your future. In the insurance are basically indemnities. Okay, insurance are basically indemnities. Indemnity we will deal in detail in future. Or you can take this as an assignment and read about indemnity in India and indemnity in other nations, and indemnity and insurance in other nations. And you can improve your aptitude by reading those areas. So insurance, it is not betting. We are not making a bet on whether you will meet with an accident or not. Okay, that is a protection scheme. They are just protecting you. They are trying to protect you. They are not trying to bet on you. So you have to understand that concept. Okay, so indemnity is basically a protection related thing. It's not a betting. Okay? Just keep that in mind. You can read about it later on. So I had to make sure. No, you have to understand what is the difference between D, B, and C. So insurable interest on a future uncertain event does not mean that is a protected interest. Okay, protected interest, that does not mean a betting on a reciprocal promises of betting on a future uncertain event. But what it is more appropriate, C is the most appropriate answer here. So please understand the difference. Insurances are not wagering. Okay, insurance are not wagering. Insurance are indemnity. Okay. Now, A promises to sell B a car if B's shipment from Germany arrives safely. The shipment never arrives. Can B enforce the contract? Now try to answer this question, please. Try A, B, C, D. You can write your answers on your papers or in the comment section. A promises to sell B a car if A is promising B what he will sell a car if B's shipment from Germany arrives safely. His shipment from Germany should arrive safely. The shipment never arrives. His shipment didn't arrive. Can B enforce the contract? Can B ask A to give that car? So with simple logic, you know that it is not possible, right? It is he has given a condition. You have to get a shipment from there. If you get that shipment from there, I will give you a car. You didn't bring the shipment, so I'm not giving you the car. Okay, so basically that works here. No, the condition was not fulfilled. Okay, it doesn't matter if you are ready to pay or not ready to pay or anything, because the condition was you have to get the shipment here. Now, Ravi and Akhil bet 10,000 on whether it will rain in Trivandrum on Onam Day. Okay, we have already discussed about rainfall and all those things. I have already told you that it is a wagering agreement, so it will be void. So it doesn't matter, right, if you read this question or not. It will rain on Onam Day, and Ravi loses but refuses to pay. Akhil sues him. Will the court enforce the payment? Will the court enforce the payment? Tell me. Will they? What we have just learned right now is that these are void agreements, right? These are void. The court will not enforce it. So even though the other person won the bet, I am not paying, he cannot go to court and enforce it. That's the thing here. Will the court enforce the payment? No, the court will not enforce the payment. Why? Because it is a void. It is legally void. We have learned that, right? It is legally void. That's it. So now we are done with contingent and wagering agreements. Now we will be dealing with quasi contracts. Okay, you have to understand what is the meaning of quasi. Okay, you have to understand the meaning of the word quasi. The quasi means as if. Okay, as if, which means like that. Okay, something like that. Quasi contract, something like a contract. So basically what we are going to deal here under the heading of quasi contracts are certain circumstances. Okay, so there are certain circumstances. In these circumstances, the formal structure of contract may not be following. Okay, we will not be following a formal structure of contract. Even though we are not following this formal structure of contract, there still exists a contract. What's the idea? The formal structure of contract, we know the formal structure of contract. What is the formal structure of contract? We are making an offer, then he accepts, it becomes a promise, then we will look into the consideration. So there is a valid consideration with each other, it becomes an agreement. Then if the objects are not illegal, it's fine, then it will become a what? Contract. That's what we have dealt before. Then there is capacity, then the object, the consent, there are different elements inside that. So in quasi-contract, what is the important thing that we have just learned? Under quasi-contract, there are circumstances in which this formal structure is not obeyed. Even if they are not obeyed, this will lead to a valid contract. So quasi-contract are circumstances which are valid contracts. The circumstances that we are about to learn are valid contracts. They are valid contracts. Okay. So these what we are about to learn is the opposite of what we have learned before. Okay. Everything that we have learned before does not apply in these situations. So that is what it is all about, quasi-contract. Now let's learn what is a quasi-contract. So the quasi-contract, try to read with me and also take a pen and paper. So we will divide this situation into simple headings. In quasi-contract, there is no real contract arising from meeting of minds. In quasi-contract, it is not required that there is a meeting of mind. But law attributes to a meeting of minds means I am asking someone, can you sell this for this price? And he's yes, I am willing to sell that. So that is a meet. We are meeting our minds. Like I am interested in buying, he is interested in selling, and there is a consideration. So that meeting of mind will not happen. Is not necessarily will not happen under a quasi-contract circumstances. So but law attributes to particular situation rights and liabilities which are similar to that of a contract. A quasi-contract rests upon the principle that a person shall not be allowed to enrich himself unjustly at the expense of another. A person will not be allowed to get enriched, okay, unjustly enrich on the expense of another. It means you should not become rich on my expense. Okay, on my unjust expense. Okay, you can get rich. Law is not saying that you should not get rich. Law is saying you can get rich on yourself, or on your own work and on your profit. That's all fine, but you cannot enrich from my expense. That is what law is saying. So the wrongful enrichment, that is what the law is trying to prevent here. Now let's look at it. So these are A, B, C, D. These are different circumstances that we are going to learn today. First one, a person who has supplied some necessary to a person unable to enter into a contract due to any disability such as minority, unsoundness of mind, is entitled to be reimbursed from the property of the incapable. What do you understand from that? Try to read it and understand. So you need to put a heading here. Okay, you need to put a nice heading here. Now the first heading, first example of quasi contract, you can say, you can give a heading here, necessaries. Okay, necessaries supplied. Okay, necessaries supplied to a minor or insane person. Necessaries supplied to a minor or insane person. What happens when we supply necessaries to a minor or insane person? We have already read that. I have already told you that what happens in such circumstances. When we supply necessaries to an insane person or unsound person or to a child, we can get the reimbursement of that what we have delivered to them, not from themselves, from their property. If they hold some valuables, we can get, if we can get money from their valuable assets, we can get that money back. That is what this statement says. I will make it simple for you. If take an example, if for a child I have spent money for his education. Okay, that is not a child who is not mine. I spend money on his education, who does not have father or mother, something like that. Or if I saw a child, orphan child, and he needs medicine, so I brought him medicines. Or some, that these are the things that are called necessaries: food, medicine, education. These are necessaries to sustain life, not luxuries. These are necessities. So we supply certain necessity to this minor or insane person. So now I need to get my money back. I have spent so much. Now I need the money back. Or now I find out that he has many assets. He has a good amount of value. He has some big property. Now it has coconut and coconut tree, and there are coconuts. So can I get my money from this? I can get my money from this coconut. I can tell that I want that amount of worth coconut from your property. You can say that, it's fine. Okay, so that is what it means. We can't get him to work. We can tell that you owe me 1 lakh rupees. So now you have to work for me. You have to go to work and get me that money. No, we can't. That is why it is mentioned specifically that property, you cannot make him personally liable and make him work for you or ask him to go work for it. There is no personal liability, but the liability is upon his property. Just understand that specifically. So what is the first circumstance in a quasi contract? The first circumstance is when you supply necessary to a minor or an unsound person, to a person who does not have a capacity to contract. Even when you are giving necessaries to a person who does not have a capacity to contract, it does not matter. If you are giving necessaries and if he can repay from his properties, then you can get your reimbursement of money. Reimbursement of money. What is reimbursement of money? Getting the money back. Getting the money that I have already spent for him. Now I am getting that back. That is called a reimbursement. Getting it back. That is called a reimbursement. Because in that way we can get reimbursement of money, which is against what we have learned before. What we have learned before is a contract with a minor is void. Now we are learning when we are supplying necessaries. There itself we learned that when we are supplying necessaries to them, we can get that back. We have learned it there itself, and that comes under here. That comes under a circumstance of a quasi contract. Now let's look at the second circumstances. A person who is interested in the, look at it, this is the second heading. A person interested in payment of money, which is another is bound to pay and therefore pays it, is entitled to be reimbursed by the other. Look at it again. A person who is interested in payment of money, which another is bound to pay and therefore pays it, is entitled to reimbursed by it. So this simply means that, okay, I have my coaching center, I have my class, or I have my house. I have a coaching center. I have a coaching center in a building which belongs to another person. Now this guy is in US. So now the municipality officers came here and he told me that you haven't paid the land revenue for last 10 years. Now we are going to start our attachment process because you have a big arrear on tax payment. So now I am a person interested in land because my business runs on this land, but this land does not belong to me. It belongs to the owner who is in US. And I tried to connect to him. I am unable to get in touch with him. So I paid his land tax for 10 years. Now later I get in contact with this person and I asked him for money. And he's saying that I'm not going to reimburse you that money because I didn't ask you to pay that money. Why did you pay that money? So you paid that on your own. So I'm not going to compensate for the money you paid. So can we claim that money from that person? Law says yes, you can claim that money because you are a person who are interested in the payment of money, but which is bound by law to pay by the other person, which another is bound by law, because it is the owner who was bound by law to pay and therefore pays it. Okay, because I am interested in land, I paid for it. So in this situation, I can get the reimbursement from that person, even if here there is no offer, no acceptance, no promise, nothing has happened here. There is no meeting of mind. I haven't asked him. Here what happened is on my own interest. I paid it on my own interest. So in this situation, the formal structure of contract is not obeyed, but it does not matter because he shall not be allowed to enrich on my expense, right? He shall not be allowed to enrich on my expense. So law says that you can get the reimbursement from the owner. So that is what applies here. Now let's move on to the third heading. Now you can read the third one on your own. Try to read it, please. So you have read it, right? So it's a very easy concept. Repayment of money for non-gratuitous acts of another. That is the basic heading. So what you have to understand, what is gratuitous? What is gratuitous? The gratuitous, the word itself simply means that something we have done as a charity or as free. Okay, we are doing this for free, of course. We are not interested in being paid. We are just doing this as a service. So that is what you call a gratuitous act. Non-gratuitous act means you are expecting to be paid. You are not doing this for free. You are expecting to be paid for doing this. So payment of money for non-gratuitous act of another. So though there is no contract as such or contract is invalid, when a person has enjoyed benefit as a result of what another has done or done non-gratuitously, he will have to be compensated. So sometimes when you read here, one more statement has to be there. He will have to be compensated. So for you to understand, I will give you a example. These cases comes mainly in service related. These cases basically comes in service related cases. Okay, in cases where there are appointments, when the government has made appointments in certain cases and the appointment is not through an improper channel. So consider I am a lecturer, I am a professor. I have been admitted as a professor in government law college. Now I am teaching at this government law college and I am teaching for 3 months, and then there comes a case that someone is stating that my appointment is through improper channel, and yes, my appointment is through improper channel. So now I will be suspended or I will be dismissed from college from my appointment. So I have worked for 3 months, and think about a circumstance where in these 3 months I didn't get any payment. Okay, they didn't credit the salary on my account. Now what the actual thing is, we have done it several times. There are several cases in which we have asked for that salary, even though his appointment was illegal. It is improper. His appointment was improper, but he has worked for 3 months, and this service was useful for the college and government. Now, even though his appointment was illegal, he has done some work, right? And he did that work not because it was made as free. He was interested in getting payment for it. He worked there because he wants payment for it. So now in this case, he can get that payment even though his appointment was illegal. If he has worked for some time, then he is entitled to get that payment. Okay, this is the most complicated scenario. If you look at a simple scenario, I'll give you a simple scenario. A person has appointed me to construct a home for him. So I'm constructing a home while I have laid the foundation. And after I have laid the foundation, he is saying that no, I am giving this order, this opportunity to some other person. I'm not interested in your work, or you don't have to continue this work. Then I can ask him for the work done. Okay, I have done this much work, now I need payment for that. Okay, you have to compensate for the work that I have done. So that is what we call the quantum merit. Okay, as much as he deserves. What we get in this situation? In this situation, the compensation will be in manner of quantum merit or merit, whatever you can call it, MERUIT, quantum merit. You will understand that in remedies in breach of contract. So I have done this much work, right? Even though this is not completed, I have done this much work. Then now you have to pay for the work that I have done, because I didn't do this gratuitously. I am not interested in giving this service free of cost. I always expected to be paid for it. So that is the circumstances. So when the work is half done and they are giving this to work to someone else, you can ask payment for the work that you have done. Okay, in real life scenarios, we are doing this in related to appointment cases. You have appointed me. The appointment itself is an illegal appointment, but what to do? I have worked for you for these many days, right? Or these many months, right? Now I have to be paid. I didn't do this for freely. So now you have to pay me the salary. So that's what we are dealing there. Payment of money for non-actitious act of another. Okay, and the other person has enjoyed the benefit from it. They have received a benefit from it. What if I have made a foundation that is very bad? That is that thing they are not going to use, or if it is of low quality, then they will replace it, right? If they are replacing it, I cannot get a compensation. He should enjoy the benefit from it. He should get a benefit from it. That's a very important point. Even a person was appointed as a teacher. I have taken classes, right? I have taken classes. So you have got that benefit. Those classes were good. If they are taking that class, if they are arguing that no, we are taking these classes again because it was bad and he didn't have enough qualification, if something like that, if their argument is something like that, it can fail also. So it will depend on those things. So this is the area we use to claim that money. Everything depends upon the argument or what happened later on in that fact of case. So this is the area we use for arguing. Okay. Next example of a quasi contract. A person who finds goods belonging to someone else so if we find a good belonging to someone else, then we have a duty that of a bailee. Okay, that is, you must take reasonable care of that thing you have found, and you should try to find the rightful owner and return the item. Okay, there is no actual contract. You see, nobody gave that to you to take care. Okay, you just found it randomly. Now, when you find that thing, now you have responsibilities like you have to take care of it, you have to find the real owner, you have to return to him. You cannot just take that and sell it and get enrich yourself. That is misappropriation of property. You will learn that in crime. If you find some lost goods, some lost ornaments in the ground, and you take that and you suddenly sell it, or you suddenly pawn it to make money, then it means you have committed the offense of misappropriation of property. Okay, so the finder of the lawsuit has certain duties and responsibilities. The duty is to take care of it, find the real owner, and return it. So it is an example of a quasi-contract. So what do you mean by a bailey? Say bailey comes under the heading of bailment. Okay. And then there is also another kind of contract. So these are special kinds of contract. Okay, bailment, a pledge. These are special kinds of contract. You don't have to know the details of it. You just have to understand the basic concept. Okay, bailment and pledge. These are actually of same class of things. Bailment and pledge or pawning, okay, is basically same class of things. Bailment means, I'll explain what that is. Bailment means you are an owner of a vehicle, a car, and you are giving this vehicle, your vehicle, to some other driver for taxi driving purposes. So he will use it for taxi driving in the morning, and he will return that vehicle in the evening. You will get a commission, or you say for one day you have to pay me this amount and you can use this vehicle. This is the basic example of bailment. You are delivering something to someone, and he can use that for certain purposes, and then he have to return it. So this is basically bailment. So to whom we deliver, that person who has taken the delivery, he is called a bailey. So now he have my vehicle, he can use it, and he has to return it. So that's what happening here. Here, even though there is no contract, he hasn't delivered to me, there is no existence of a proper contract. When a person finds a lost good from the ground, when a finds an ornament in the ground, he has all the responsibilities of bailey. Even though there is no contract of bailment, he becomes a bailey. Now he is asked to take care of it, find the owner, and he has to return it. That is the situation that arising in that area. So I have just stated pledge. What is pledge? Okay, pledge is a specific kind of, it is a specific kind of bailment where we deliver goods as a security for payment. For example, our parents gives our ornaments to some FinCorp organization to get some loan, right? So here that ornament act as a security. Here it is a bailment, but we are delivering thing specifically as a security for repayment of money. So it is a specific kind of bailment. Okay, bailment itself is a special and specific kind of contract. Okay, in that special area is pledge. So that's it. Here the thing delivered will become a security. There we are delivering a thing, and he will do the work and he will return it. That's the basic concept there. You have to just have that idea. You just need to have that idea. That's enough. You don't have to know every aspect of it. You need to know when someone says pledge, when there is a written some statement about pledge in a passage, you understand, oh, so this is pledge. You just have to understand that. That's enough. Now that's the case there. And the final situation, a person receives money or goods delivered by mistake, is obliged to return or repay. If I am making a payment and the transaction went for some other person, I intended to give it to B, but it went to A. Now A has a duty to repay it. A cannot say that I didn't ask for it. Okay, there was no contract. I didn't ask him. He didn't give me a promise. There is no contract. There is no structure. I don't know this person. It doesn't matter. It was a mistake. So you have to repay it. So in these circumstances, we have learned some circumstances. In all these circumstances, the important thing is here there is a deviation from the formal structure of contract, and it does not matter. It would still remain as contract because they are as if contract. They are kind of contract. So law accepts it as a kind of contract. So it's as if, quasi means as if, it's as if a contract exists. Law presumes that as if it's a contract, I'll accept it. So what are the situations? Necessary supplied to a child or an insane person, necessary supplied. Then comes repayment of money paid by interested person, which is bound by payment of by another person. So repayment of money paid by an interested person. That is the second heading. Third one, repayment of money for non-gratuitous activity, for the work done non-gratuitously. That is third one. Fourth one, for the finder of lost good. And fifth one, money paid by mistake or goods delivered by mistake. These are the 5 circumstances. Whenever there is a case relating to these 5 circumstances, you understand. Even though there is no formal structure of contract, these are contracts because these are quasi contracts. So we have now learned about quasi contracts. Now let's try to work out whether you understood it enough or not. So let's try to answer these questions. First question, try this first question. A principle is given and a fact is given. The fact is A unknowingly sends a cylinder of cooking gas to B's house. B uses it. A later asks for payment. E is bound to pay. So even if you don't read this principle, if you understood the concept of quasi contract, you can answer this question, but read the principle also. Yes, because B used the gas and A did not intend it as a gift. No, because there was no contract between A and B. No, because A sent it by mistake. Yes, but only half the price since it was unintended. So the answer is very, very simple, right? The answer is very simple. It's because B used a gas and A did not intend it as a gift. That is the answer. Very simple thing, that is mistake, right? Or the principle that we have learned at the end of quasi contract. Now the next question. Okay. So the next question. Suresh, a tenant paid 20,000 as electricity dues to avoid disconnection in his landlord's house. The bill was in landlord's name. Can Suresh recover this amount? Okay, can he recover this amount? Okay, we know that it is a recoverable section. I have provided section here, which is not important for your exam. Okay, sections are not important. So these are recoverable amounts. Okay, see, while reading this question, you might misunderstand with the real life incidents. In real life, when we are staying at a house as in rent, we will be the one paying the electricity bill, right? That's the same. That will be like that. We cannot get the reduce that in our electricity bill. So what? Because while making the agreement, we will write like, okay, water bill and electricity will be paid by the tenant itself. But what if we joined it as a tenant and a previous month's bill comes? Okay, we just joined there this month and the bill arrives from the 2 months before. That we can reduce from the rent. The owner will always reduce that from the rent. Okay, that's the concept applicable here. Yes, what we can recover that money. That is the answer. So now moving on to the next two. The sections comes under section 70. Okay. Sections are not important for your exam. You need to understand the core concept. Sita received 50,000 toys due to the bank's technical error. She withdrew and used the money. Which of the following applies? Which among the following? Sorry, answer is already there, but you know, we have to return the money, right? We have to return the money because it is an example of quasi contract. Money paid by mistake. So that's it. Now we will be moving on to discharge of contract. The discharge of contract. How a contract is discharged? How can a contract come to an end? Every duties given under a contract is discharged. There is no more duties and responsibility. No one has no more obligation. How does it happen? How can we end or discharge a contract? So there are several methods mentioned here. There are no passages here or anything. I'll just explain to you how this contract comes to an end. So first one is by performance. The contract is said to be discharged when the rights and liabilities created by it comes to an end. Rights and liabilities created by a contract, when it comes to an end, we say that the contract is discharged. That's it. First one, by performance. By performance means everybody played their part, everybody did everything that they need to do. That is the by performance. Then comes by agreement or novation. Okay, performance, that's it, we performed it, end, it was the end. Now second is the by agreement or novation. So there already exists a contract. We can create a new agreement upon it and put an end to the previous agreement or contract. If you're confused how that works, I'll give you a scenario. Think about this scenario. Okay, think about this scenario. A owes B 5,000 rupees. Okay, A owes B 5,000 rupees, and B owes C 5,000 rupees. Okay, now this is a pre-existing two agreements. Now we create a new agreement. Okay, on the basis of this scenario, we can create a new agreement with A and C. Since A owes B and B owes C the money, now making him as a promisor, we create a new agreement in which A will pay C 5,000 rupees. Okay, so by creating new agreements, we can discharge previous agreements. That's the concept here. It can be between same parties or between different parties. It doesn't matter. But by an agreement, we can destroy another agreement. That's what is by agreement. By agreement, we can destroy another agreement or another contract. Next method is by impossibility of performance or doctrine of frustration. Sometimes in your question paper you will see statements like the contract frustrated. So you will become confused. What is the meaning of frustration or frustration of contract? It simply means that a contract has become impossible to perform. The possibility of performance has become null. It is impossible to perform. That is what the frustration of contract means, like, because now it has become impossible. A person has made a contract with me that he will deliver me 100 kilograms of A grade rice or something, but suddenly a flood came and it got destroyed. Okay, he promised me it on a certain date, 20th or 25th. Now what happened was that there is a heavy rainfall and it goes destroyed. Now suddenly he can't give me that product, right? Because it takes time to grow. So now it has become impossible to perform. So when some contract by any reason, it may be a fact of God or maybe by law or for some reason this has become impossible to perform, then the contract will seem to be considered as discharged, because it is not possible, it is frustrated, it is impossible to perform. So there will be no more contract, the contract will become discharged. Now what comes next is by breach of contract, because one party has violated the contract. Now the contract is discharged. Now one person has violated the contract or breached the contract. Now the contract is discharged. What we can do is we can claim for damages. We can claim for compensation. You have to understand damages. The word damages in law is used as synonym for compensation. Okay, not damage, damages. Okay, so we can claim compensation when there is a breach of contract. The contract has become what? It has, when we breach a contract, the contract has become discharged. Now we are claiming compensation. So by breach of contract, by lapse of time, if we have mentioned a time for contract, we will deal in this material, we will transport using your service, or we will deal with you for these many years. That many years is over, the contract will become discharged. If there is a time period dimension, after that period of time the contract will be discharged by operation of law. Sometimes the law itself will discharge the contract. Sometimes the contract will say the law will say that from tomorrow onwards you cannot make contracts, or the existing contract on these subjects will cease to exist. Law will make such commands of such nature. Like for example, in some states there are alcohol and alcohol beverages chains that supply that, and suddenly a government can come and say that, okay, we are banning all forms of alcohols, there will be no more alcohols, this state is going to be a dry state. So now there exists a contract between two parties who says, okay, I will deliver you these many beverages and I will have this many, I will pay you this much amount. There is a valid contract that exists in that state between two parties. Now since the law has declared it as an illegal contract, so you cannot the object has become illegal, so now it cannot exist. You cannot make a contract on this beverages because alcohol is illegal in this state. Now you can't use that contract, right? Then by the operation of law, this contract has become discharged. Our agreement will be for 5 years. So after the first year, the law, there is a new law making a state what a dry state. So what happened is, even though the contract is valid for 4 more years, you can't have it no more, because what it has been discharged by the operation of law. Okay, the law, by the operation of law, the what happened, the contract has become discharged. Why? Because you can't perform it. Law is not allowing you to perform it. That is what's happening. So these are the different methods. The law itself will discharge the contract sometimes. Sometimes since the time period is over, it will become discharged. Sometimes the party has breached your contract, so it will be considered as discharged. Sometimes the contract itself become impossible to perform due to many reasons, then it will be considered that discharged. And by performance, if we have played all our parts, so we have done everything that we need to do, rights and obligations are over, then the contract is also considered as discharge. So these are the circumstances. Please keep this thing in mind for your future. And to the final part, a contract is said to be discharged. Sorry. To the final part, we'll be looking at the different kinds of remedies. What are the different kinds of remedies that are available in case of a breach of contract? When we feel that our contract is violated, what are the remedies that you can, that are the solutions that you can ask to courts? The first one is damages. I have already stated that damages is synonymously used in law for compensation. The party who has suffered since the other party has broken the promises can claim compensation for the loss or damages caused to the in the normal course of business. In his normal course of business, what loss I have incurred, I am asking the court to get that money from the other person, the person who made me suffer. I want to be compensated from him. That is the compensation, simple damages. Now, rescission. What is rescission? Try to read that. When one party to a contract does not fulfill his obligation, the other party can rescind the contract and refuse to perform his obligation. So in contract, what it says is that when the other party is not doing what he has said he would do by the contract, and if he is not doing that, now you don't have to do your part also. Okay, sometimes in relationship to contract between some multinational corporations and small units, some small scale business industries, the service MNC provided to these small companies will be of more value than what they give us. So when these small corporations are not doing what they are supposed to do, or if they have done something that is against our policy, now we will cut all service and all supports that we give to them. So it will be a huge loss to them. So they will go to court and they will tell them that because they cancelled this contract, I had so many sufferings, because believing that they will support us, we have made many promises to different other businesses, and now it has affected them. They can go to a case for such matters. So what happens is, I will come and tell them they have violated our policies, they have breached our contract. So we completely rescinded this contract because they didn't play their part. So why should I play my part? Yes, they are suffering a lot more than us, but it is majorly because they haven't done their part of the contract, right? So that is why I am rescinding. So it is a kind of, we are punishing them. Indirectly, we are punishing them. So it happens in some circumstances. So just understand that damages means asking compensation. Rescinding means rescission means I am not doing my part because they didn't do their part. Simple as that. And quantum merit we have previously discussed in quasi contract, right? It simply means as much as he deserved. He should be paid for what he has done. Now let's look at it. Quantum merit literally translate to as much as he earned or as much as he deserved, whatever it is. And at times when one party of the contract is prevented from finishing his performance of the contract by the other, so one party is prevented from completing the contract, he can claim the quantum merit. So he must be paid reasonable remuneration for the part of the contract he has already performed. That is what we have discussed already, right? So we have to pay for the part he has played, for the services he has done for us. So now we have to pay for what he has done. That is as much as he deserves. That's basically what it is. Then specific performance. Specific performance means we want them to honor the contract. We go to court and we say that I don't want money from them, I don't want anything from them, I want them to do it for me. Specific performance, it means the party in a breach will all actually have to carry out its duties according to the contract. In certain cases, court may insist that the party carry out the, we want them to carry out this agreement. For example, Apple and Amazon. Apple's displays are provided by Samsung. AMOLED displays. These are delivered, made and delivered by Samsung itself. These are competing companies. Even though they are competing companies, they have an agreement between them that Samsung will deliver them the display panel. So now what happens if suddenly Samsung says, I'm not delivering this Samsung LED panels, okay, AMOLED panels. The problem with that is in market, Samsung LED panel, AMOLED display is the best display you can get. Nobody is making such a quality display. So Apple does not want a compensation from Samsung. So even if I get a compensation from Samsung, if I go to any other creator, some other manufacturer, I'm not gonna get the same quality of display, right? So I want him to deliver me that. I want him to deliver me that. So this Apple will always ask for what? Specific performance, because in market no other player is making the same quality of display. See, so in certain cases the party will insist on specific performance, because if he doesn't deliver it, I don't get that quality material, or I can't get that from anywhere else. So I want him to make it. So that is the specific performance. Then it is injunction. Injunction is basically a negative specific performance. Let's look at it. Injunction is basically a degree of specific performance, but for a negative contract. An injunction is a court order restraining a person from doing a particular act. So here injunction means, simply means, what is an injunction? Injunction means the court is saying stop doing that. Injunction means simply that the court is telling someone to stop. Please stop doing that. That is what injunction means. To make it simple, think about the case of Reliance Retail, Future means Big Bazaar and Amazon. So there existed a case between these parties that when Future Retail, that was Big Bazaar, was in big financial trouble, they tried to sell some part of their business to Reliance Retail. Then Amazon intervened. Amazon intervened and said that there is an already existing contract between what this Big Bazaar and Amazon, that Future Retail will never do any kind of business with Reliance, because these are competitors, market competitors. So they made an agreement that we will continue to do business because Future Retail will not have any business with Reliance. So Future tried to when Future was trying to sell their shares, sell their some business with the Reliance, it affected their contract. So Amazon went for a case and they asked for a injunction, saying that what is an injunction? It is a negative specific performance, right? They are asking them not to do business with Reliance, because I want you to specifically perform what you have said in a contract. You have said in a contract that I will not do that. A negative sense of specific performance. They are saying I will not do that. You while entering into a contract said you will not do something. Now you cannot do that something right now. Okay. So the court said that court gave an injunction. That case went on to happen for long. We don't have to get into the details of that case. I'm giving it as an example. So this is how injunction work. So these are the remedies. These are the solutions you can claim in a court. You can ask for compensation. You can ask for specific performance. You can ask for injunction. You can rescind the contract, and also you can ask for quantum merit. Whatever I have done, I need a payment for. with this session, we are winding up our law of contract foundations. See, believe me, you have completed everything that you need to know about contract, every key aspect. If you have any confusion with these key aspects, just go back and revisit it. You know the offer, you know the acceptance, you know the promise, you know the consideration, you know what agreement is, or you know what a contract is, you know what are void, what are voidables, then exception to the rule of consideration, quasi contract, but this breach of contract, remedies for breach of contract. You have learned every key concept relating to contract. Now all you need is you need to look back and get it in order, and you can try other materials, other guides, or whatever you want. You can try. If you are reading those materials, you will understand that you know everything that you need to know regarding this area, this particular area of contract. Okay, thank you everyone, and we will see in another session.